Hi friends, I hope you are having a fantastic day today. Welcome to Lawn Looks, where I smoosh together law and makeup to talk about some of the more fun or interesting cases I learned about in law school while doing my makeup. Quick disclaimer, nothing I say can or should be construed as legal advice. I cannot give you legal advice. If you do need legal advice, please obtain your own attorney and seek counsel from them. So it has been a while since I have made a video. I was taking the bar exam. You might still be able to see some of the bar exam exhaustion on my face, but that's okay. I've just been sleeping and watching a lot of Netflix. But I am back to talk about another case and also use my brand new Pat McGrath Celestial Mega Palette. I am very, very excited to use this palette. It's so pretty. The shimmers are amazing swatched. The mattes were not my favorite, but let's see how it works. I'm gonna try and use this palette exclusively, but I might go in with my true and tested Lorac Pro 1 palette for some things if I can't make it with this one. But I'm gonna try and just do a simple shimmer look, and we'll see where that gets us. Let's dive right in. So today I want to talk about a foundational property law case, Pierson versus Post. It's all about that wily fox. So this case answers, or attempts to answer, that quintessential, Eurocentric, philosophical question of how do you reduce wild nature into personal property. That's what we're looking at. And it all hinges on a fox. So this is also probably one of the most famous property law cases in American legal history, and when you read it in law school, you're like, why on earth am I reading like some 16th century nature tree? What's going on? The way it's written is just like really like old-timey language, and you're like, what? And why am I reading about a fox? And then you proceed to read about whales and spearing a whale, and anyway, yeah. So, oh yeah, if it wasn't clear, this case involves hunting. Am I recording? Yes, I'm recording. Haha. So the premise of this case is fairly straightforward. There's this guy in 1802 named Ludwig Post. Post lives in Southampton, New York. Of course, we're in Southampton. And he's out with his little hunting party and his hunting dogs. And the dogs catch the scent of a fox, so they start chasing it. And Post pursues this fox along with his hunting party. This is a favorite pastime of the sportsman, the gentleman, I suppose, in the 1800s. So as they're chasing this fox, they get like super duper close to it. And then this other guy comes along, Jesse Pierson. It's always a Jesse, isn't it? Jesse Pierson kills the fox and takes it with him. And Post is so mad about this that Pierson just like took the fox. He sues Pierson to say the fox is mine. Give me back the fox. I mean, it's like 3 years until the case is like finally decided, so it's more like the fox is now gone, but give me the money that the fox was worth. Anyway, Post is like, I saw the fox first, the fox is mine. And Pierson's like, finders keepers. I found the fox hiding, I killed it, and I took it, so now it's mine. The trial court initially finds for Post. They were like, he was the one chasing the fox. He's the one that saw it first. He gets to keep the fox. He's entitled to damages from Pierson stealing the fox away from him. Pierson was like, no. And he appeals. And it goes all the way up to this highest court in New York. At this time it's called Supreme Court of Judicature of New York. And the Supreme Court reverses the trial court and says, no. Pierson gets to keep the fox. And they get there through probably one of the most annoying opinions that I have ever read in law school. My eyebrows are not going well for me. I think I need to pull the mirror closer. I need to fix my eyebrows. What am I doing? Basically, what the judges did was they decided not to follow common law on wild animal capture and just like haphazardly put together a random assortment of different treatises and like legal expert opinions to come up with this new law of wild animal capture. I think they looked at like 6 or 8 different treatises. They just like kept pulling from one, and you're like reading this opinion trying to figure out like how it comes together. So they look at all these treatises and they look to the definition of, oh wow, that's a very pigmented brown. Okay, so they look to the definitions of these beasts, ferae naturae, I think it's how it's pronounced. Is that Latin? Oh, traditionally known as animal ferae naturae, wild animal. Yeah, I'm just gonna assume it's Latin. If you know that it's a different language, please let me know. The court looks at all of these different definitions and different treatises. They see that the definition of ownership for wild animals in a lot of these treatises is the actual capture and possession of the animal. That you're in corporeal possession of it, that you have actually obtained physical possession of that animal. That's who claims ownership to the animal. Whereas traditionally it was thought of as the person who gives chase to the animal is the one who thereby owns it. Okay, I need a bigger, floofier brush to make this happen, I think. Blend. I may have forgotten how to do makeup while studying for the bar exam. I just like put that information in and all my makeup info dropped out. Let me blend this and then come back. Okay, I can't blend out these Pat McGrath mattes. I think I don't know how to work them or something, but this is as good as it's going to get. So we're just going to move on from that, and we're going to go back to talking about beasts and ferae naturae and possessing a wild animal. So basically the court says that this common law requirement of having control over your possessions, that giving chase to the animal means that you have control over the animal, that's no good, and that would lead to a slippery slope in the law. And we can't have that because slippery slopes are bad. Essentially, if you are only chasing the animal, you haven't actually got it in a trap or mortally wounded the animal, you are SOL, because the court says it would just cause too much litigation. I mean, clearly we're here, we're fighting over a fox, right? If the common law brings us to this point every single time, the courts are just going to be inundated by hunters saying, no, the fox is mine, no, the fox is mine, no, the deer is mine, no, the deer is mine. And courts really don't want to deal with that shit. That's why the court says that Pierson is entitled to the fox, because even though Post is the one that started the pursuit, Pierson is the one that actually caught and killed the fox and took it out of nature and subjected it to himself as personal property. I'm gonna go in with Lorac just to highlight. While the majority rules in favor of Pierson and says, sorry, Post, they do note that Pierson was a little rude in pursuing the fox, knowing that Post was also pursuing the fox. Pierson held strong though. Pierson said he had no idea that Post was pursuing the fox, but we'll get to that. Yeah, the court chastises Pierson a little bit, saying that, hey man, what you doing? Why are you trying to hunt down somebody else's fox? That's not yours to hunt. I mean, it is yours now, but, you know, there's some societal norms we follow here. But it doesn't matter because Pierson wins. There is a dissent, and the dissent basically says, what are you guys doing? You have just, like, made this extremely complicated. And also, we should leave this question up to the sportsmen, the people who hunt. If you ask any normal sportsman, any hunter out there who would own the fox, most of them would say Post, because he's the one that started the pursuit. The dissent also says that ruling in favor of the person who starts the pursuit encourages hunting and ridding the countryside of these wild and noxious beasts, and he's the one that calls the fox a wily quadruped, which is hysterical to me. The entire case is a little funny to me. It's all about this one fox and who owns the fox. But it might have gone deeper than just the fox. There was a law review article written by Bethany Berger in Duke Law Review called "It's Not About the Fox, The Untold Story of Pierson v. Post." This law review article essentially goes through the history of Southampton and argues that it's less about a fox and more about control over the resources in the area. The article goes through the history of how the population of Southampton came to be. So it goes through the English settlements and taking of land from the indigenous tribes in the area. And by the time we get to Pierson v. Post, there have been lots of different controllers of the resources. There's also been a lot of natural disasters, earthquakes. The land isn't really that ripe for farming. So there's a lot going on with this land. By the time we get to this case, or the incident that led to this case, essentially Pierson is descendant from like old money, essentially. He's the son of like the original town proprietors, and he inherited his land from the original settlers. Versus Post's father became rich through the West India trade, so he's essentially new money. And there's basically this big dispute over who will control Southampton's natural resources. Will it be the proprietors or will it be the local residents, these people coming in from new money? And essentially what's happening is that Post, with his new money, is kind of showing it off. It's like ostentatious wealth. And people like Pierson, who come from old money, don't like that. They're like, this is not how the wealthy should behave. It's very like, it's that classic, old money, new money divide. And part of Post's ostentatious show of money is this elaborate fox hunt. And the town has distinctly agricultural roots, so this display of wealth would have been seen as contradictory or harmful to the town's reputation, because they're like, that's not who we are, that's not our way of life. Like, kind of like, stop being so tacky. And the Piersons were like, we are refined, educated gentlemen, and we do not do such things. So there's that kind of tension going on. And the historical record is very sparse. So this is kind of just a theory that was put out in 2006 by this law review article. This article contends that this dispute wasn't really over a fox, but it was really over who would control the town's natural resources and how would the social organization be set up. Like, are they staying with the old money line of thinking and structure, or are the new money people going to come in and take over? So that idea kind of gives credence to the fact that Pierson probably knew that Post was doing this fox hunt, even though Pierson contended in court that he had no idea that a fox hunt was going on, and he just saw this fox hiding and caught it and killed it, and that's how he attained the fox. That's probably untrue. Pierson probably saw this as a way to undermine Post and undermine that ostentatious display of wealth and maintain the power structure and the social organization in place in Southampton at the time that essentially said that the proprietors, these old money people, are the ones who are going to continue to control the resources and the distribution of those resources in Southampton. I actually had a lot of fun researching this case and kind of learning about the town and maybe some incentives of why this was all happening because of a fox. Because reading it in law school, you're always kind of like, okay, what's going on? This is kind of absurd and like funny. There's so many memes about it. But, you know, let me know what you guys think in the comments. What you guys think of this case, about the background. Did you learn about it in law school? And of course, how do I pronounce Fere Natuar? I'm not even gonna try again. And that, my friends, is Pierson v. Post. Thank you so very much for watching. I also wanted to do a shout out to a really funny t-shirt company I found online. They like briefly brief cases onto t-shirts and mugs and stuff. It's called Held. They have one for Leonard v. PepsiCo. I'll try and put a picture right here. And they also have one for Pierson v. Post and a bunch of other cases that are interesting and fun that I have covered or that I will cover hopefully in this series. And yeah, thanks again for watching. If you enjoyed this video, please, you know, give it a thumbs up and subscribe to my channel if you feel so inclined, but no pressure. And I will see you all next time. Bye!